Good afternoon, Mrs. Bensouda.
Mrs. Bensouda,
good afternoon, Council.
Council.
I hope you had a good break.
Yes, thank you. Thank you.
Unfortunately, because of the Ramadan, we are not able to offer you TRRC hospitality.
Thank you for offering it in any event.
Mrs. Bensouda, just before the break,
Mrs. Bensouda,
the chairman preempted me by going into decree number 1.
Sorry about that, Council.
That's all right.
That's what chairmen do.
Indeed. And this was the first decree that was passed under your tenure as Attorney General, Acting Attorney General. And I believe there were 5 more that were passed under that capacity. Perhaps we can, before we go into the decrees, just give us a background into what was happening in the country then at that point. After you had met the chairman, and he had indicated his desire to rule by decree. And gave you instructions for the drafting of decrees. In terms of the human rights situation in the Gambia, then what was the situation?
As far as I could ascertain, and they really depended a lot on rumors.
Ntesikolo itandiro nyame wotembo kujama bedendi munela menketa ngunu kumoliti moyla moy kumolu menukafo.
As I said, all ministers had been detained. I believe all senior military officers above the rank of lieutenant were also detained, barring the only person I know who was above the rank of lieutenant, I believe, was Lamin Kababajo that I met, who was not detained.
Andu tembo sojar bunda la menul fanala makamo be lieutenant ye santo. Wolo jamabe kono ye mutaleke sindidula keleng. Fase ke mo kelinti de Lamin Kababajo ni me nyoje. Men mantara mutamolu kono utumo.
All senior police officers were also detained.
Police kunyaton kolu fanalu be ye be fanan sindidula keleng.
There was a great deal of tension in the atmosphere.
Utumo sobinyolo sembo be wararim bake fonyo kono.
Most of the vehicles you would see on the road were military vehicles driving at top speed to and fro.
Wotembo ekamoto jamaje siloka beka ke sojar moto leti inimbori balu bitakan tani na betala bina.
And as far as you were concerned, the detentions of the minister as well as the others you've mentioned, were they lawful or not?
Minister ni kemura ke sindi dulakiling ani mansa kunda do kula nyato ka kota kemura ke sindi dulakiling ani tanko bunda kota mo kemura ke sindi dulakiling itala londoro fo oni luata talama.
Of course they were not. Nothing that the military could do would be lawful. Did or could do would be lawful.
Amanke luati. Katu wotembo sojaroli ye kundinke wotekeno la luwa la siloti ye membeta manda ni luwa manta.
A military government is not lawful.
Sojar man sakunda fawni luwa le manta.
And at that point, I agree that it wasn't lawful. Do you remember or do you know any other human rights violations that occurred during that time, apart from unlawful detentions? Because we have received a lot of testimony about how some of the ministers were also tortured during this time.
Ninga bota ni mola ni minister ni tanko bunda nyaaro nga kota mol ke muta ke sindi dula ke mo kayla o nyantu tinya fo yalla na fo hada ma nyanti tinya dol ketal ban katu nga seda ndur jamal der soto janko minister dol beje mi alon ko ye dol ye muta gabri ye sindi dula ke ye dol beje ye tajire yale ngo seda ndur soto jan fo ye dol lon na ba men alon ko ila ta ni mol kamba.
At the time, we could not know that.
O tembo de mtewolo nola.
What we would hear rumors of people being whipped.
Kama mwe wala mwe la kumol di koe ka molu mutale ke busa.
Basically, people being detained in Mile 2, not only in police stations and so on, but in prisons.
Andu ye molu mutamene ya lonko. Ye samba banko kaso bunda abala kate soronje. Hana manke police station olu damantide. Bari ye samba kate sorong Mile 2 kasola.
For a lawyer, that is horrendous because, as we all know, the only institution that can put anybody in a prison is the court.
Odun lawyer la karola wo mukijate kubaleti katu ndella ngamel dalta melna wala mnyinti ko kiti bunda leo sembo soto kamo kiti ndini lua ya muta ya sorong.
But later, through decree number 3, Mrs. Bensouda, the council was given that power to detain people.
Bare sedo nyato do mande decree sabanja on nginata na sembo di council do kula lale nyato ko lale puru isi momo murande no ya samba kaso ka sindi dula killing.
And they assumed this sort of semi-judicial function as well as other legislative functions.
Andong degree ni narana sembo di la kole comme loi bundaro kiti bundale sembo membe bulo no sembela kilingo ni narana kurundu kanao ke ka fute to council nyaton kolma kamo samba kasoto ke sindije.
Decree number, no decree gave the military any power.
Decree ti jeme ye sembo di sojarol.
The soldiers were already detaining people in Mile 2.
Sojarol ya mutale drone kamolu mutakate soron Mile 2.
Decree number 3 did not give the soldiers power to detain anyone.
Decree sabanja man sembe wo sembe di sojarol la purka molu mutake soron.
What decree number 3 did was try to put in place a framework within which if you were detained, you would be dealt with.
Decree sabanja e sarto men nati men wala mnyinti ko ni teliye muta hanfo ye sindi dula killing bitung itel lamira roto men nyanta kelela isiokela.
Received evidence that apart from the fact that this decree gave them the authority to detain, but when they actually went to court, when they were arraigned in court for offenses, that the magistrates' hands were tied, for example. They had no discretion to grant bail because of that particular decree, because it did give the council that power to detain, and that power was no longer in the courts. They could no longer remand prisoners.
Nga sedandro men so daja nyin decree sa manyo wala nyin diko nyin decree sa manyo ay sembo di nyin council members wala council mo lale kadung hanni ngatra mo mura ya samba kitiyo ya samba kasoro magistrate même kiti la nyindi aka même fo wala nyindi ko hanne bel ko nata aka fo ko mbulol be sitrine ka mbulol be sitrine u katu digiri nyi sembo tala di nyi council nyaton kolla wala ya sabu kiti la nyi aka fo ko mbulol be teddere ne nte bel dino la nyi mari la membe muto kono.
Just to put things in context,
I
was very concerned when I came at the extensive detention not only of ministers, but of so many people.
Birina tanga de unkubasoto. Wakata muneti. Hana manke minister ludam manna mutoti. Utumo ya taraye mo jama fana mutameni yalonko ibe mutoko no wotembo. Wakata de ngotinte.
As I said, when I engaged the chairman in that meeting,
about
the release of the ministers, he refused except for the Attorney General.
Minister labulo fire ka foi nyante bulalele abalantale na manke Attorney General.
I did not raise at that meeting the release of any other persons.
Mammo dolu labulo mama ndije de wo meeting bulato je.
And when he released the Attorney General and I went with the escort, Alkali James Gay was also in the same room as the Attorney General.
Bring nga Attorney General Labula ko fire hanufo in atante dandam pour kansamba. Ndata tu moment Alkali James Gay fanambe o bunkil ngolo kono aning Attorney General.
Sorry to
I'm just trying to put things in context.
Yes, I was wondering if you were going to come
Yes,
to my question.
I will.
All right, thank you very
I'm
much.
giving you the context.
Thank you.
It concerned me that Alkali James Gay could not be released.
Akitanya de unkoti wairi Alkali James Gay ni Attorney General be bunkono kilingolo kono. Imanso wo bulala wole ndeun.
The following week, I was called to a council meeting.
Alo kungo membulata onoma yankumande purngata mabe council bengoto.
And I advised that based on, advised that they could not keep detaining people without charge, particularly in Mile 2, because the detention of all these military officers came to my attention, and it was raised at that meeting.
Andu bring tata wo bengoto. Ngani na faje ko yimmo mutoni mo sorongo dinkira kilino tata tenten no la satara ime tu mi be mankule kan luwa nyati lingula. Kato tembo ne ajibe ye mo jamal le muta men yalon ko ye samba Mile 2 be mutolu kono andu mo kuleti me yalon ko ati tano la nyato pour kabula wonya.
And that under our constitution there is a procedure for the review of the detention of persons under states of emergency.
Adumotu monte la sarto lukono nyimbije la ko sankan jubero nyanta kala muta molu la kolu lale ning imutata foka pare ko anyanta kitama la nyami nim misali kama bankola sarto lubelore.
They made it clear, especially the vice chairman.
Ya seneyandi bake sako chairman nolanko.
And Mr. Lieutenant Singate, who I met for the first time at that meeting.
Mr. Lieutenant Singate, me ya lonkolem sinya floating nabe nyojela obendulato.
That the detention of officers, military and police officers, would not be compromised.
Ko nyaton kolu menu mutawo nya katabula police nyaton kol la wala muto falinte keno la woto.
But they agreed that they could subject the detention to reviews.
Bari sontako wo mutolu kamolu sindi isi sonne jubero ke ila kuoto
by a tribunal.
Andu membe wo jubero ke la wo ke la kitindir bundati.
They also agreed that going forward they would disclose the detention of people by actually issuing detention orders.
Andu ya nyum fanam fala ko kolu bitaka nyamin ibe molla muto itandila nyamin wala nyinti ibe kangolle itandila menketa sartol ti pour ka molu muta.
In other words, as far as I was concerned,
nyado nyama ntela karola ntela mira roto.
Detention decree number 3.
Decree number 3,
which is the state security detention of armed and police personnel decree.
Me ya lonkolem decree ti meye bankola kantonin tankada bunda nyaton kolu muta ke sindidula kiling.
Actually forced the military.
Amunta we sojaro lo aye iblo aye forcele.
And curb the excesses of what they were doing.
And I wole mu kuti me ya lonko telbella na tambi kolu menu kekan pour kalo dula ke wala.
Force them to let people know
aye force fanam puri mol
who they
ya
were
lo
detaining.
telbe juma le muta e juma le muta ke sindi.
It afforded the people detained an opportunity to make representation.
Tum wole nata molu mako men be mutoko no pour fanal simo nyini men be lo leye.
And it put in place a procedure whereby their detention can be reviewed.
Ando anata kulondi me ya lonkole nyinti ko ila muto isisa kan jubero keno ila muto dalilo lale.
But let me emphasize
that
the decree did not authorize them to arrest anyone.
Aman sembe wo sembe dila pour kamo muta.
These people were already detained.
Yimmolu yolu muta le foka pare.
A decree does not add, so to speak, does not empower, does not give the military any power that they already did not have.
Decree buka sembe di sojaro la sembo me ya lonko wotebulu foka pare.
Mrs. Bensouda, let me just interject at this point.
Mrs. Bensouda mbarunga bantambili nyaro nyintimben.
I understand that your position is that when you came as acting Attorney General, you came to basically stabilize the situation.
nganyim fam le wato men karfar Attorney General detail inata dinkiram palaso ni yata men kam wala nyindi ko ka dinkira nyinta ka tembendi.
You're also saying that the decrees were just a status quo.
Andu ibe info ko nyi decree nyi mu kulle men yalon ko hakili bulandi kulle ndo yalon ko kulla nyaabe nyamen.
And that in fact it did not give them any powers that they did not already have because they were detaining people.
Andung man sembo di la me alon ko mamben soto kadung ndaro yo kelon hanun kabi koman.
However, I wish to put it to you
Hanin kabi nyaayo nyonya kilmo nyaambe yitandile la ko.
that the decrees
Ko nyi decree nying
legitimized everything that the military government was doing at that time
sojar mansa kundabe koku ke kanu aya be sabatindile
by giving it the force of law.
be menke kanu anarna somebody la luala karola.
First of all, let me just clarify something.
Follow mbaranga dinkira kilin sen yandi.
The military did not appoint me as Attorney General.
Sojarolu mante tembo ka Attorney General makamo dinna.
There is a Law Officers Act.
Wotumo lua
There is a law.
Lua bije.
Mrs. Bensouda, I'm sorry to interject again, but kindly just perhaps answer my questions first and then explain.
Mrs. Bensouda bunya kono na nyinin karo nyin ajabi nga nyinin ka nyamen ro.
You really seem to be deviating a little bit from my questions. I would like you to address them directly and then perhaps give us an explanation or some context.
Amulundam vele ko na nyinin karo nyibe jenke kan na nyinin karo nyine pour ka ajabi de.
It's not my intention to deviate. This is about what, 25 years ago? And the answers require context, but I'll do my best to answer your question first.
Kolu ibe bularinyo no manyame ibe dendi nyola nyame barbitumba katalale itala nyinin karo nga okungulu jabi.
Thank you very much. And also just within the context of, the limited time that we have available as well.
Andu ibe jabi la nyame bularinyo no manyame fana si hakilo bulandi fana wato men fana bembulu amansia ba.
We have quite a few topics to cover.
Andu fanna jamal lebe je mealon ko nyenna kachala.
Thank you, but sometimes the context of your question requires clarification.
Inumbara bartumandolu ila nyinin karo akoto kama nyinin ka foil dinkira dolu sata e senea.
What I was going to say was that by the Law Officers Act,
in the
absence of the Attorney General, Solicitor General takes over the office of Attorney General.
Attorney General, Solicitor General lekao office o tamandi.
So notwithstanding whatever announcement they made about permanent secretaries, in the absence of Attorney General, effectively I was Attorney General.
Italy FMFN kankula bitung abelari nyaunyandi nyama, where Attorney General TJ Solicitor General ninkum wale kalo palaso to kaukulu tamandi.
And not by virtue of any authority conferred on me by the military.
Mandu abanke dalila wo dalila tikafu sojaro luwele yo sembo dintela.
And going back to your question,
ila nyinin karo kang
military governments do not need legitimization.
Sojar man sakunda lulu bukanyin kanin kafu mko membentela ko tilindi la kake tonya koti wala kake ku sahari ngoti menni sartolu sita.
Their authority flows
itella sembo nin kango wakata male.
From their guns.
Andu wo akabumune bala ila kidolu menu bebulu.
They have taken over the country.
Ye banko tale.
They are de facto in charge of the country.
Amunta otembo etelebe mararim bankola.
Against our will.
Akule memandi antoliye.
The only way anything can be legitimized if it is legitimized in accordance with the Constitution.
Kokundi sitilindi no nang ayatara misali kama an inconstitutional la kama tata no nyola mosio le kumandi no tilindi rote.
So decrees do not legitimize
Oto decree olubuka tilindi rote
the action of the military government.
Mensike sojar mansakunda la kuke taliti.
Decrees may give it a structure.
Decree ulusilo dula dila.
They may put in place a system.
Isikuolu fanalu tamandinya londi.
They may put in place a framework.
Isikuolu fanalu lanya londi.
But they cannot legitimize.
Rita tilindino la kafunyi mulu lua sarti lori ngolete.
Mrs. Bensouda, the decrees give force of law.
Decree le sembo di luala.
And that is exactly what it did, because even as the Constitution stands, the decrees are recognized as one of the laws in this country.
Andunga wala ke handung hani ya jibe va nyin decree wala mu kude me alon ko sutendro dita wala la bake fanka ke luwa de nyimbanko kan.
And at that point, in fact, they even took supremacy over the very constitution.
Andung wati na sort of nyin decree nyin na tambi ka maralo ila maralo na tambi ka tambi na luwa buku ba wala.
If you look at decree number 1, which you drafted,
andun niya jibe decree follow nyi me alon ko ite wala safe.
Although it did not suspend the entire constitution,
to nyala amang na luwa buku ba nyi ma be bayde.
There was a provision that said whenever any provision of the constitution was in conflict with the particular decree, the decree would take precedence, it would be supreme. So therefore, in my view, decree number 1 as well as the other decrees that were passed during your tenure really set the scene for dictatorship in this country. I understand.
Decree following and decree dol me along wala bulata decree following no kan wol bem keda decree le me along wala na tuturo ke kula me along sembela maralo nying banko kanja.
I understand that you do not recognize or did not recognize the legitimacy of that dictatorship or the government at the time. However,
nganyim faham le ko iman suden roke ando iman suden roke nyin tiko nyin decree nyin ko kulle me alon ko itilintale andu bar hanu kabi wonyaaw nyarandi nyama.
That was the status quo.
Wala mu ko nyin la nyaati o watola.
And unfortunately, in your position,
andung man tiling nyaaw onyaakil ngo nyaawa bari itela palaso to.
And as also parliamentary, ex-parliamentary council with expertise in legislative drafting and all of that, you were very instrumental.
And we get a more alonco Londo to Safero to Luara Carol and we get a parliamentary council di imu more alonco Londo to Baka Kunyintole.
In giving them that framework
Kunying Alhalo Nyinta Kadila,
within which to maneuver and navigate.
And Geto is Jenkenole for Canono.
Thank you. I think, with respect, Council, we are confusing certain concepts, I think.
Inumbara Council, baringa mera mbe kodolu jeka nyaming abe kekan nyami nyololeti.
It wasn't the coup d'etat of 22nd July 1994 was probably one of the last coup d'etats in the sub-region.
July karotul muanim flo coup d'etat ngamera asekeno wolem coup d'etat labango timenkata nyintundola.
From the 60s up to 1994, there were various coups across the region.
Kabo 1960 sangolula for kana 1994 coup d'etat jamal lekata tundo nyina.
Military governments rule by decree.
So jarman sakunda lukatamani decree la.
All the Ministry of Justice could do was to draft the decree for them.
Minister Bunda me marta kito nintilingala wala kama nkeno drong wala mkao decree wala safe yeni yakani.
They do not need decrees to justify their existence.
Itelubuka sula nyin decree wala puruka ila law anila sembo puruka law ndika tilindika sembentu ya.
They don't need decrees. In other words, they don't need a decree to rule.
Ni ajube nyalo nyama. Ema sula decree la puruka mararoke.
They had removed the legitimate government. There was no decree for them to come in and remove the legitimate government.
Italy mansa kundale bondi me ya lonko ole molla mansa kunda loringoti. Iman sula nun decree la janibe o mansa kunda bondila.
There was no decree when they arrested and put the ministers in jail.
Decree ta kerin nun bribe minister lumutala ke soron kasola.
They did not need a decree to subvert the constitution.
Iman dik sula decree la nun puruka bankola constitution or yelemandi.
But the country which they were ruling required decrees in order to understand what the military government was about. So did the decree set a scene, as you put it? No, the scene was already set. Was I very instrumental? If you mean, did we, by instrumental, did we...
You assisted the government. You assisted the military rule. Because you said they had a blueprint. So you assisted them to accomplish that blueprint simply by drafting those laws.
No, they did not need my assistance to follow their blueprint. If you mean, did I put that blueprint into a coherent framework in some of its respects?
Yes.
I was the Solicitor General in charge of the Ministry of Justice. Were we to close our doors and ask everybody to go home? No. The country needed a government. Now that the legitimate government was gone.
Mrs. Bensouda, you said the country needed it needed a government.
Yes.
You have said the government was not legitimate. You have reiterated that because you said there can never be a legitimate coup.
No, I said the coup was not legitimate. The military regime were not legitimate. The military government was not legitimate.
Yes,
but there was an establishment. Let's make a distinction between those who were in charge and the establishment that they found. I was part of that establishment.
And I am I'm talking about the military government as it stood. Did you recognize its legitimacy or not?
And to be
specific, Yaya AJ Jame with his junta members, as sitting as the council, did you recognize their legitimacy at that point?
No. Nothing I did could legitimize.
If you did not recognize their legitimacy, why were you answering to them? Why were you working for them? Why were you obeying their instructions? Why did you go ahead and draft all of those decrees?
But
I was as I said, I was the acting Attorney General by virtue of the Law Officers Act. They did not need my recognition. They just needed my skills to reflect what they did and what they wanted to do in a framework, as I said. It cannot be called law. Because, but that's why they are called decrees. They were going to rule by decree. But the public needed to know the rules of the game. So my role, if I may just put it succinctly, my role was to prepare the instrument as requested, and that was the decree. They don't need my legitimization or my recognition. They did not.
With all due respect, Mrs. Bensouda, you're still not answering my questions directly.
Mrs. Bensouda hankabi bunya konorong hankabi nanyin karonyi imatra jabi kang ko afurate manyamen.
And I will ask some further questions, and yes, I hope that you will assist us with answers, direct answers.
And hankabi mbenyin karo dol nyin kala la purisa je isindema purisi jabi.
Very well, Counsel.
At that point, you had the skills, like you said, you had the know-how, you had expertise in drafting decrees.
These soldiers, with a difference, had their blueprint, they had a concept in mind. sojarol men yalla nata if inata ko itol nata ni kula nyalla mi yalla ko itol bi mu sojarol mi yalla ko kolbe fatala lay nin hila fansung hamol len nata ko ya fo nyame
which they communicated to you as the acting attorney general.
Andu ilaw hamen ko wolu nyinga nilaw ferol nyi membe to yo be foyende ne tumala men tabun attorney general yabe karfari telamanu.
They had no idea how to carry out this blueprint.
Itol mum molde mi yalla ko ma londi soto ko pour que lay hamol nyinke tamande ko luwaya yitandi nyame.
They had no idea how to draft decrees.
In
fact, if you look at your statement, you'll see that you had to do some sort of comparative analysis between the different military regimes at the time. And using that, you had to come up with a draft which you felt reflected our unique circumstances here in the Gambia. And this draft was presented to the council. And I dare say that the contents of the decrees were very much influenced by you.
Andung kumakan me alon ko ila kumakan wala andung mosi itaman no ila wala
because you selected those particular provisions which you felt were appropriate.
Adu itele mu moti me alon ko yo kumakan nyin tombo andu ya jele ko itela mira ro ko kumakan nyin kumakan me alon ko isabati isikeno la ni itamande.
And these were later passed.
Andung nyato do mande nyin kumakan nyin atane munafaila.
Yes, Mrs. Bensouda.
I lost the question. That's a very long statement.
And it's very similar to one of your answers, Mrs. Bensouda, because your answers are also very wide, very long-winded.
What is the question, really?
You provided assistance to the junta at that time. Without your skill and ability, they never would have been able to come up with those decrees by which they ruled this country.
Personally, I don't agree. I happen to be the person there. I couldn't say that without my skills, they would not have been able to rule this country.
By decree, Mrs. Bensouda, I'm talking about the decree specifically.
The decree, I don't agree, just to answer your question first. The military, as I said, don't need a decree. They were already in charge.
Mrs. Bensouda, I believe
let
you
me
have...
just say, it's the situation that needed a decree, not the military. Let me just say further, they could have continued as they were, giving orders without a decree.
Mrs. Bensouda, I believe your point is well taken, yes, really, on that. But I wanted you to answer whether or not, you said without your assistance, they could have actually come up with these decrees. Is that what you're saying?
I'm sure they eventually would have.
Without the assistance of the legislative.
Let me just say, the impression that people have that these are a bunch of stupid, innocent people who did not know what was going on. It's not correct.
They certainly did not have...
they had done their homework, as I said, and they knew about decrees, that military people rule by decree.
Mrs. Bensouda, did they come up with a draft which they presented to you, for example? They had so much knowledge on decrees.
No, they did not come up with a draft. They asked us to provide a draft.
And you did.
It'll nin draft manade. It'll ya kanin tolle bulupur ka okaito da.
Andu yo kele.
Yes,
Ah.
we did. But even if I wasn't there, whether they would eventually have gotten somebody else to draft something, I believe so. But we were the ones there. They asked us to draft it, and we did.
Nin tel tije nun lata la ko. It'll be fair do tamandilale. Ibe silolu ninyin dikriolu soto na nyamin television tije. Andum na kita nu wonya fana. Abe tamala le it'll be la kolu kelale.
The fact of the matter is that this is not a hypothetical situation. You were the one on the ground. You were there. You were acting Attorney General at the time.
Tuanya mendola nyi manke mawur kuri tele benu je tele munun Attorney General yabe karafari tele ma tele benu office nyi to watola.
And therefore you would have been the only one to do the job at that time.
Amda woto ite dronde mbe kala moti no watola membe odu ko nyi keno le. Andu yakele.
Yes.
And that is what I want you to take responsibility for.
So sa in left ak puriye yeso wala yedu nota.
What is there to take responsibility for?
That you assisted them to draft the decrees.
Ko itele de ma pour ka nyi degree nyi take safe.
It was my role as the acting Attorney General to receive their instructions. To in turn instruct the Parliamentary Council. And I did.
Very well, we'll take that answer and I'll leave it to the Commission to decide.
But whether I take responsibility for the decrees?
That was not my question. No, that was not my question. My question was that you were assisting them. That is all I said. I did not say that you came up with a concept or the idea. That has already been well established, but that you assisted them to draft it. You could have said no.
Na miro nyinara waranto itele na hamo nyinara bari itele de ma pour ka nyin decree nyinta ka safe
adu isafo no le nun hani biri afoye
I could have said no.
Isafo no le nun hani
probably, but as far as I was concerned,
bari ntela kungu nte kundingo na mira roto.
What waited on me was the public interest. What was in the interest of the public at that time.
Membentem sondo matuno walem jamaa molu la solo mumenti wotembo.
Could we contain the excesses of the military?
Fodo itelbela na tambikulu menu keka ngotumo fo nsiolu londino leba.
Certainly decrees were needed.
Tuonya auto solo be o decree wol lalenu.
Not for the benefit of the military.
Bara manke puru sojaro la nafade.
But for the benefit of the people.
Bara puru molu la nafa.
And are you saying, Mrs. Bensouda, that these military decrees actually benefited the public and that they were in the interest of the public?
Munta se do ka men fo la nyindi ko nyi sojaro la decree nyi nyi men findi amuta ka fo ko jamala nafa le ba.
Especially considering all the evidence that we have received that this was a tool by Yaya Jammeh to entrench himself in power in this country.
Surtout abe ko no wala nyindi nga sedandirol men be so jang mo jama ya fo jang ko nyimu luwalle te me alon ko Yaya Jammeh ki munafa ila la dram pour ka fan tutu samboro.
The decrees that I drafted. The decree that I drafted was in the interests of the public. Now the public chose in 1997. Chose in 1997. Instead of repealing these decrees, they were incorporated in the 1997 Constitution.
In atao decree olutaye dundi 1997 Constitution kono sarta bukuba nyinkono.
The greatest part of the violation of rights which occurred in this country
nyantatinya sembe maba menketa nyimbanko kang
occurred after the 1997 Constitution came into effect.
Beketa brin 1997 constitutional in lota hani for atamando damutata.
Those decrees are still in our statute books.
That is
the choice of the Gambian people, not the Solicitor General or Mrs. Bensouda.
Amanka Gambia dingulu la 40 de wala Solicitor General wala Mrs. Bensouda.
Amanke Mrs. Bensouda la 40. Gambia dingon la 40.
Amanka ha you abant.
Thank you very much, Mrs. Bensouda. I appreciate your opinion on that. But let's just have a look, perhaps, at decree number 1. And perhaps you could comment on it briefly for us. And I will just guide you whilst you do that. You agree that the decree had retrospective effect?
In
its operation.
The decree was given effect as, I think it was effective from 22nd July.
And when was it passed?
Yeah, that was the day on which they took over power.
When was it passed, the decree?
The decree was promulgated on the 29th of July.
Between July
So it had retrospective effect.
It had retroactive effect.
Very well. What was the date you reported to the chairman after you came back?
The same date, the 29th.
And therefore this decree was passed on that same day.
It was announced that evening, but the publication was actually done the following week.
So therefore it was actually, was it gazetted?
Yes, it was gazetted, but as you know, I mean,
that was done the following week.
It was done the following week, yes. I don't have the gazette publication, so I cannot tell you the gazette number and date, but it was gazetted the following week.
Yeah, gazette
And of course, it's apparent that these decrees were churned out very quickly, because in the space of 15 days, whilst you were acting Attorney General, 6 decrees had been promulgated.
Decree
Yes, 6 decrees were promulgated whilst I was acting. Was overseeing as Attorney General, yes.
Wato membe Attorney General ya makamo tamandikang wo decree worolo findita utumole.
These decrees, unlike normal laws, would go through different processes and would take months, sometimes to actually pass.
In decree ani loi ko tango dol ning janni bezala ke sabat ne ke lualti wati jamal beje kata ka dingira jamal le ma folo wan ka kari jamal le da folo janni be sabatin la ke lualti fo.
In the instance of decree number 1 was passed within 1 day after you consulting with the chairman.
Misal fe degree number follow nyim fo keda degree me alon ko lum follow mena enin kiaman dara le be men so lum kilo nyina ya tambindi ka ke luati.
Yes, that is the nature of military rule. You don't have to take it to anybody. They are the executive and they are the lawmakers at the same time.
Wala msojaro la maralo Kenyati katu kundonka ya betele bulu sembo betele bulu bitu preta kumen na ikatama ni wale nyama.
Isn't it true that even in this particular decree number 1, they were also the judiciary?
Fo nyim manke to nyaade hani nyin decree follow nyim fanam kiti bundal fanam bejele mem judiciary.
No,
if you look at
the chapter on the judiciary was not suspended.
Ani sarto membe dendi judiciary la wala mkitindir bundati mao dende.
Mrs. Bensouda, if you look at the provision of the decrees taking precedence over the Constitution,
ni decree follow nyin jube pour katambi constitution nyin mem musarre loi marale buku ba nyindi,
which was within the sole jurisdiction of the Supreme Court at the time, or the courts. The fact that even the courts could not question the validity of the decrees. In my view, gives them judicial power.
ndela mira loro we sembo dida ko itoldem kiti ndir laldi
because the courts were no longer relevant. Were
ka
they?
tum kiti bundalo man kumaya ko tanke
So they assumed that role.
ro ya munda ko itol council mol ni tolle o du palaso nyinta ka kiti ndir laldi
I don't agree.
Manso Otola.
Decree number 1 as drafted did not oust the jurisdiction of the courts.
Decree number 1 sabata nyameng wa mankiti bunda la kango burkade.
Did not suspend the courts.
Mankiti bunda lu deng.
Not expressly, but by implication it did.
Manke ko kokuma kango ya afanya men bari bitum alanya wala kiti bunda lu deng.
I don't also agree with that.
Manso wo fananda.
Can you tell us why?
Afanya mune yo sa.
If you're not able to resort to the court, if the court is not allowed to question the validity of the decree and cannot interfere in the operation of the decree, and the decree is supreme to the Constitution, then I don't see what the role of the court there is.
Ni misali kama kiti bunda man sembe soto kakuta mandi woto.
I'm guided by my learned senior.
Yo adung anataka kuti meya lonko. Kiti bunda ma sembo soto kakuta mandi je adung imang ko kundi noje. Woto silang woto kiti bunda lunafa lodulale.
I think you're referring to Section 5 of Decree number 1.
Namina decree number 1 wala decree
Yes,
flow la bunda lulu njango ibole mateng.
As well as the other provision that it goes to, if you read it in context, it talks about the supremacy of the decree over everything else, the Constitution and the courts.
Aduniaji be vita afuta la dulato dame ya lonko wala decree nyina kebayati katambi kudo lula men ya lonko wala be laren kata hanfo Supreme Court from la sartol.
What that means is that the courts do not have the jurisdiction to question whatever is done by decree.
Wala mnyindi kiti bundalu itelu emang nyin lod lasro kanyinin karoke decree nyin ay kolu menu landi wala ay kolu menu tamandi.
But that does not affect the continued existence of the courts.
Bari wo man kokundi soto kiti bundal la loning ila tamo Kenya la nibe kering.
And let me remind you that this provision,
Bari ngi hakilo bulandi ko nyin sarto
in a different formulation,
ning abelanya do nyama
exists in the 1997 Constitution,
abe kering nun ko 1997 Constitution okono
and it's still binding on the courts.
andu hanimbe ataketa kuti membe larin na kiti bundalu kang.
So the courts continue to exist.
But kiti bundalu continue to katara kering.
And I did not say the courts did not exist. My point was that as far as this decree is concerned, the jurisdictions of the court was ousted.
Mafoko watu ya tareko kiti bundal mantara tamakan. Bari ibe tamakan no watu bari komi ila lodlali nyanta kamintano umufenete miana ko mantara nje.
Insofar as they cannot question the validity of a decree, yes.
Ning ayatara decree nyin na barako ete nyinin karte kenola wala baydata kenola.
I will move on. I will move on, Mrs. Bensouda, unless you have something else to say. I'll move on to the next point.
Be continue la fona atara fendo be bulumia lefta kamin fo.
And it also, this particular decree actually suspended a part of the Constitution, which was Schedule 1 of the 1970 Constitution.
Wala nyin decree nyinga keta fennete mi alonko na banko luwa buko nyinga akatam banko katama luwa buko min far sarro dolbi je mi alonko nyin decree o landele mantara tamakan koteng.
Sorry, Schedule 1?
I believe so.
Schedule 1 wala bunda followed.
No, the provisions that are suspended are in Schedule 1 of Decree number 1.
Amunta bunda lumeni alonko yedeng wolube sarto nyin na bunda follow nyin nela.
Yes, so it's suspended.
It's Chapter 4 of the Constitution.
Chapter 4, yes. Chapter 4 relates to the President and his cabinet.
Sapanani njang betilindi president na la cabinet la wala ala maral kafunyolu.
And therefore the council was now sitting in that place.
Sa kamdoko council nyimbe siring.
The chairman and the council were sitting in the place of the president and the cabinet.
Chairman ana denyol walen council ti be siring no dinkrala do mi alonko president na la cabinet la nyanta taran.
Yes, they became the executive.
Ay telna take kundon koluti.
And I'm aware that although there was not a wholesale suspension of the Constitution, but this definitely paved the way for that happening later in Decree 30, I believe.
Na yele ko koma man ko na bangulu wa buko ni ya bele londi imana bele londi bar kabru wato na yin decree londi ka fo mi decree 30 wole silo di fo katano.
Sorry, I don't understand the question. Pave the way for
Suspension of the entire Constitution.
Me silo walang pour que constitution obede.
In Decree number 1, a part of the Constitution had been suspended.
Decree number 1 na banko luwa buko katama minna.
And later on in And later on in Decree 30, the entire Constitution was suspended, including the fundamental rights sections.
And fanani nata jibe Decree 30 wala satro bunda nying tansabo nying ni ajibe wala nata keko komin sam banko nyanda tamala luwa buko minna yobe londele fa da fongo bulata je fongo hanama dingol la nyanto fongo yo fongo bondi jele.
I understand that you were not in your position at that point when Decree 30 was passed.
Nga fahamle ko wato mi yalon ko nyin Decree 30 iba londi kanno wayata rete man taranje.
But I'm saying that Decree number 1, which you were involved with, set the pace.
But mbafula ko yaje wo Decree number 1 mi yalon ka yetaraje wala funga silo walang fo nyin Decree 30 lotano.
No, I don't agree. Decree number 1 did not, as you put it, set the pace. Nor did it pave the way. What Decree number 1 did
Decree number 1
is to suspend all those provisions which were in the Constitution, which were no longer relevant to the situation.
Sarto lumeni alonko itella jero to mankumma ya kolu lanya fe ya wolle deng.
There was no president or cabinet.
President keri nutumo sako cabinet.
So the chapter on president and cabinet were suspended.
Bitungo tumo wo bunda me marta wala president in cabinet utumo yolu deng.
Most of the provisions which follow
are
consequential on those two main factors. There was no parliament. The chapter on parliament was suspended. So that is what Decree number 1 did.
Decree number 1 la
Now Decree 30, which came into force on the 29th March.
Decree sabanjango menata March karokono
1995.
Menketa 1995 sangokono.
Actually suspended the fundamental human rights provisions of the Constitution.
By
then there was a team that was advising, a legal team advising the Forces Provisional Ruling Council directly.
Wotumo lua kafuso tontale menube ni sojar kafo ya marikang menube loringo palaso totumo.
These were not Gambians.
Ulumanke Gambian koluti.
And I believe their advice was that there was no place for a human rights chapter in a military government.
Nga mera itilaya maro ketanyineti ko. Hadamaya nyanta lodula manyan sotola sojar bunda la mararoko.
I believe that even before Decree number 30 was promulgated, in Decree number 1, there was no place for human rights anyway.
Latalako, jamning Decree 30 from Decree number 1, where it endro kalako hanama dungolanyanto woman dinkraso to wato nyimbangoka.
By the fact that not only was the jurisdiction of the courts, which were established to protect fundamental human rights, ousted.
And wobe kam fanga terakiti bundabe loring miya lonko wala nyanta katankandiro ka hanama dungolanyantola.
But also because the decree was supreme as well to the Constitution. And definitely we know the spirit in which the APRC junta came and the various human rights violations that were committed, as you alluded to. So the spirit of Decree number 1 was against protection of fundamental human
to
rights.
sa e bajala ko nyin decree sarto mi alon ko ya londi ala dalilo minto wala nyin pre kana hadama dungol la nyanto ka tankandi.
I don't agree.
Nteso manso wala.
Decree number 1 did not suspend fundamental human rights.
Decree following number 1 among hadama ya nyanta to nyalu among hadama ya nyanta bundalu amedende.
So it enabled us at the Ministry of Justice consistently push for the military junta respect human rights.
Thank you very much. Perhaps we can move on, and I will allow the Commission to decide on that point.
Baraka.
We've looked at decree number 1. Can you just guide us through the rest of the decrees that you assisted the junta to pass?
Decree number 1 ngola ko fole sa mbella filame na wala nyindiko yemma koy decree mi yalan ko hete dablo to wala kono mi yalan ko wo junta man sakunda nyi wolle de dano.
And to buttress my answer in respect of the non-suspension of decree, the Fundamental Human Rights chapter of the 1970 Constitution.
Anin kanna kuma kango bambandi ka foko decree number 1 amang hadamaya nyanto la kunya lu den ka ben 1970 Constitution okono nyaming.
The Monday following my return, that is the 29th was on a Friday. On the Monday,
karotil mu anin kononto benta jumole febril nata bitum tenengo membulata onoma.
A state council rushed to my office.
Kiti ndirila sotonta menya moto futata na office. State council sotonta menya moto futata na office.
Lawyer Mansalam lawyer mo mialonko.
And said that managing directors had been arrested.
Akoye managing director mutale.
And were sort of being paraded on a truck.
Koye bulandi moto bale kono ibe yitandi kankata.
In Banjul.
Banjul sate kono.
So I rushed to State House.
Nyamoto tata State House.
Because when I met the chairman, even though he was talking about setting up commissions of inquiry, this is one of the things he said in his discussion with me. He had specifically said there would not be a witch hunt.
Ite bula nomo kila kabula molu noma wonya ke ide mako ekabualu de manyami.
I was ushered in to see him.
And
I protested the arrest of the managing directors.
Bitungana balanda itandi ala jele managing director la mutokang.
I told him that this was contrary to his assurances that there would not be a witch hunt.
Nanyim faya woto nyinila kumakangulu fatata le kafoko ite bula no kango kela molula.
And particularly their humiliation by being put on a truck based on mere allegations of corruption. So he called in Lieutenant Sanasabali.
Lieutenant Sanasabali commandi.
And Sanasabali said that these people were corrupt and were criminals. That they had been taken to Mile 2. I stood my ground and reiterated and remonstrated with them that they could not put people in Mile 2 without trial. Finally, they agreed that the managing directors would be released. And he promised to call me and confirm when they were released. And that evening, he phoned to say that he had given instructions for them to be released. I could not have done that if there was no fundamental rights provision in the Constitution, or if fundamental rights had been suspended. As far as I was concerned, And more importantly, as far as decree number 1 was concerned,
adun ka kola kuma ya jube decree number 1 fang fanana karola
fundamental human rights chapter in the Constitution was operative.
hadama ya nyanto sabatin dolu neng abaru malu banko kan utumode ibe lorinne.
And we, that was why consistently we emphasized that human rights had to be respected.
Wala nan continue kanyim bambandi ko hadama ya nyantolu e nyante bunyala le ke londi ke bambandi.
If I can just make a comment there, Mrs. Bensouda.
Mrs. Bensouda.
The operation of human rights and fundamental rights was not
coming. Hadama dingol la nyanto e nyantaka loa la nyaming.
It wasn't protected through the provisions in the decree or the constitution. This was a special effort you made to free these individuals. And that is why they were freed. That is not how fundamental human rights operate. They should operate freely by law or by the constitution. And as far as I'm concerned, the decree number 1 superseded all of those provisions of the constitution. And just to preempt you before we get to decree number 3, if you remember the case of Chongan and others, they were acquitted and discharged by a magistrate. They were basically listed in the list that was attached to decree number 3.
And they were security detainees. And komi molle milia tanko bunda mol dokula molle moit and ye motale mabo.
Despite the fact that they were acquitted and discharged,
yimbe kanko komin kitio nata fola ko nge bulale kito ye bulale andite murundi nola ye kitindi ko bang nyanto tinyal minke wala ye kuol minke.
The overriding power of decree number 3 applied in that instance.
Decree nyingi nata na wota ka lekang wo watu ngisudunga fonkon.
So therefore, like you said, even though the courts were functioning,
but hanisa mba fola ko hanatra wo watu kono kiti bundale be doko la ko nyanta doko kala nyame.
As well as the rights under the 1970 Constitution.
Comme fona nyantol mi yalan ko yole di handama dungola na banko loi buko ba nyinto mi yalan ko ka fole 1997 Constitution.
However, the decree superseded them.
But hani wo be decree le nata sembo soto katambi wo loi buko bati.
Was that a very long question again?
It was a statement.
I'm going to ask that you agree or disagree with the statement then in that case. I'm putting it to you.
It's difficult.
Let me shorten my question so that I can get a direct answer from you. Do you remember the case of Chongan and others?
Not the details.
What
is the date of the case?
I do not have the date of the case, but this was sometime, I believe, in 1995, if I'm not mistaken.
I'm
sure you're aware of Chongan and others being arrested as security detainees immediately following the military coup. Were you aware of instances where security detainees were discharged or acquitted by courts, but that could not happen because of decree number 3, which you drafted.
Foi hakilo bakane ko mol mi yalan ko ko tanko bunda mol le muti ye samba kiti ndiro la kiti ona tebula bar wo bula ro ni amanna sembo soto no kadu dikri le bije mi yalan ko man sakun a wo man sakun dambe kering ye fan sujini wo dikri la and wo dikri etele moti mi yalan ko ite fongle ya safe.
Which provision are we really talking about in decree number 3?
Mbe sartaj mal fo ka nyin decree number 3.
We're just looking at the generality of decree number 3.
Mba bele jibe kan decree number 3 fon fami yalan ka daba kono mba bele.
If you look at it, it states that the supreme power resided in the council to detain members of the security forces. And that because the decree overrided the constitution as well as the courts, just like in decree number 1, the hands of the courts were tied. If you look at 2.1, I'm looking at decree number 3.
2.1 of which of the decrees?
Decree number 3.
Decree number 3.
Yeah, that is state security detention of armed and police personnel. Yes, it says that where the vice chairman of the Armed Forces Provisional Ruling Council is satisfied that the arrest and detention of a member of the force is in the interest of the security of the Gambia, he may make a detention order in the form prescribed. And that is the general order to make detentions, to order for detentions.
Akamumva wala nyindiko mimbe safari woto wala nyindiko tanko bunda mol chairman sa fono le ko wala la wojunta chairman wala nyaton ko nyinga sa fono le ko nyimo tanko bunda mo nse mutano le na tara ko chairman ya jelo ko wala wo mutaro nyinga jarta la priye muta asina kamodi ko ye muta.
It also states in subsection 2 that in fact the vice chairman may direct the place that the person is going to be detained.
And fana sarado fana tato bala mi ala be chokeni wo bala mi itandro ke ko mi alon ko wole sinno be chairmano nom wose ya marodi no le komi nyimol mi alon ko ye muta wolen tanko bunda molti isa fono le dinkral to mi alon ko nyanta ke mabo wollato.
It goes on further in subsection 3 to state that the conditions of detention are also determined by the vice chairman, including even as to confinement, maintenance, discipline, and punishment for breaches of discipline.
A continue to fan kafo fan ko min dinkral to mi alon ko nyanta ke mabo damento wo be sembo tata chairman no malan ko lebul fo min tate la kulo la karola la taranyala karola nyanta min lale kan.
And we all know that even in the case of Chongan
and be alone ne min keta Chongan la karola
and Mama Cham and others,
and Mama Cham na monyol
during the period of their detention, on the 6th day of September 1994, members of the junta, except the chairman himself, went into mile 2, subjected them to brutal torture, as well as a mock execution. And who knows if that may not be a lawful interpretation of maintaining discipline and punishment and all of that. But I assume that would be under the exclusive purview of the vice chairperson the vice chairman to interpret.
But
Mrs. Bensouda, this is the decree that you drafted, and you gave extensive powers
Mrs. Bensouda
to members of the council.
The
decree, sorry, you expect me to respond, I suppose.
Of course I do.
The military officers, Chongan and others, were already in detention when this decree was promulgated on the 4th of August 1994.
Wato me be nyin decree bondila August Karotil na.
Let me just interject there, Mrs. Bensouda.
Yes.
Sorry,
But
I
then
don't want to
continue.
lose this point. We've already discussed that the decrees had retrospective effect.
Nga kaja jana ko komi nyin decree mi yalan ko ye londi na tana ko ya ku sotal mi yalan ko wolekata nun ko.
And I'm putting it to you that the reason why they had retrospective effect or retroactive effect
No andonia jembo fokan ko komi wo ko min kata.
is because
Katuko.
the council wanted to give some sort of legitimacy or force of law to their actions in case somebody decided to challenge it.
Yo ke dalilol min kama wala nyindiko isaje tol council mol fon isaje ko ye kuo kuke ye tilimbali ko wala ye kuo kuke andon ya ko milla natara wo maril pareta pour que samba kiti dulat e be min kala dore be fan suje la ni la nyin decree lu wala
Because even though the decree was not passed when that action took place, but then the law gave it validity.
But hani wo be kanko ayatara fon kabri bo ko wol nyin ke kan ayatara nyin decree nyin amanlo but hani say nata na sembonti ya ni luala
because of its retroactive nature.
Katu ko mine wotina katu ya murundi ko mala ko min ko wol min be katano.
Learned Council, with respect, no law can give validity to torture.
Luata keri meye nyin tonya yandika momuta ka tajireya.
These military officers, as you mentioned, were already in detention.
Nyim sojari nyatonkolu wayatara wul bemuto
We
kono le
had
foka pare.
instructions to draft decree number 4.
Wato me ba fulante le pour ka decree nani njawrada.
At least for the future, just taking the sections that you quoted one after the other.
Ko ka fo sining ye dinkiralu mennu banke o nya ye
But
bulandi
what decree number 2.1
bare decree fulanjango laftanu menna
made possible, at least for those who were not in detention,
ay nyin sababule mennu yalon ko tumo e mantara muto kono
that they could not be detained without a detention order.
ite wolu mutano la ke sindidula kele nin kam man soto membe o kamolondila.
Decree number 4 or section 2, subsection 2 and 3.
Decree na ninjango ala bunda fulanjango o fanana bunda lodula fulanjango nin sabanjango
Did not empower anyone to torture persons in detention.
aman sembedi mo wo mondi na pour ka molu tajire ya men yalon ko be muto kono
To the extent that the fundamental human rights provisions were still in force.
andu ko aytandi ko tumo hadama ya nyanta sartolu wolu be lori nenu be tamakan.
The decree assumes that all detention would comply with the fundamental human rights provisions.
Decree ye nyin londi ko tumo wo skolu be ni sartolu nyanta talal nyolale menket hadama ya nyantoluti.
So to say that because the decree was given retroactive effect,
Woto ka foko decree nyin hani kutambiringulo ay sembo soto leje pour ka kutamandi.
that probably legitimized torture that was going on.
Dalilo le ya kendi woto ay nyin it sembo di pour ise molu tajire ya.
With respect, it's not correct.
Woni ajube amantiling.
What I was saying that it legitimized the actions of the government.
Bamin foka wala nyindiko.
Especially when it came to
atindila ko komi wolbe min ke kan fenne miranka nin luwa tatale.
it certainly legitimized unlawful detention as we know it in the Constitution.
Aya itandila ko komi ye mo mutanda anin luwa manta ay wole bambane katu ketande ko kanin luwa tatale.
Because the procedure in which they detain people, and the evidence is quite clear here, the TRRC was definitely not in consonance with the provisions of the Constitution.
Andon fona ika bunda nin silol minta pour ka wo mol nyem muta ni ajibe kuma kongol min be fota TRC jang woni bankola luwa buku ba manta nyola.
And that, in my view, paved the way for other human rights violations such as torture.
Andu ntela miraloto anata muna wulu wala nyintiko kasilo di nyanta tinya dol mi yalan ko wolle keta molla.
Decrees cannot legitimize the actions of the Armed Forces Provisional Ruling Council. It cannot legitimize torture. It cannot legitimize detention. What legitimize? Sorry, the translation.
Decreeolu tenyin keno la ka foko ka tilindi wala ka kesartoti pour ka molu muta wala ka molu tajreya wala ka kujawolu ke molu la ke dimindi.
And the Armed Forces Provisional Ruling Council knew that the only legitimacy they can get for their action during the transition period
andu sojarolu tumo itelia lonko kuomen si itelu lakolu sambano ay keko kutilindingolom itela mararo kono
was to have an indemnity in the Constitution of the Republic of the Gambia.
Wolem kabunda londi Gambia la Constitution okono me yalonko wolebe kantaro kela molu la men yalonko ni okolu ke satara kute kelela.
That is why they went to the extent of ensuring that we had the second schedule to the Constitution, indemnifying their actions during this period.
Dalilo le ya sabu itataka bunda fulanja nyi murundi na Constitution okono me yalonko wolebe itali kantala ila kuketa lutobe menukela sartol fanan la karola.
And let me also remind you that legitimization must have an objective yardstick.
Kumbenyi mfanan fula ko ka kutilindi ka ke kutime yalonko ka ke ko kutilindi ngolong wo fanan ayala sumandalu sotolede.
A decree which is made by the military cannot legitimize what the military does. It's the decree is made by them. They cannot legitimate their own actions. So legitimization connotes that some other process is used to give validity to something a person does.
Decree olu nyili ate keno lako itel fangolu yo decree olu dera pour que itel fangolu law kuketa lu tilindi. Bari woye kule itandi ko kule be dendinga la meya lonko itel seo men keno wala mnie memmenke wo decree olu sike kuti si denno menula.
So with respect, Council, legitimization in relation to decrees is a misnomer.
Woto ni ajibe Council ka kuolu tilindi ka fo aya tembendile sartol la karola woto mu kuleti meya lonka ninyan tolu man tembe.
It is the Gambian people in the Constitution 1997 Constitution which supposedly went to a referendum that legitimized the actions of the AFPRC.
Birin Gambia no liye kon referendum o nyinke carte o fayi hani fo wo sartolu menu dunta 1997 constitution o kono wala olu sembentu ya ke londi pour ke kuti men sitama.
And from 1997
bitun kabo 1997 lumulu
those provisions in the constitution legitimizing and granting indemnity to the AFPRC remain in our laws.
Wala ya sabu sartolu mbeni itelikanta ke tankandi tilindiroma wala tutalla constitution okono wala ya kendi itella kuketalu kumanna boje mensi keitolu la kafo ya nyineke.
That is why Yankuba Ture was able to raise it.
Wala na Yankuba Ture ya kango bulindi ka okuma kangulufo.
And if you look at the judgments of our courts consistently from 1997, they have excluded themselves from having the jurisdiction to determine the legitimacy of decrees.
Gruni ajube kabo 1997 kiti teulu men beketan na banko kang woto ninkumu itelie fam bondile ke fanjam fandi wo sartolu lako wolumu kulleti men ya lonko as keno ko kusi soto men se ke tolla wala bulusile kang.
So I think it is wrong
ngamira manke kutilendinguti
to try to infuse decrees
pour ka
with an authority that they don't have.
Purka decree will ka ning sembe dundi nyola sembo me ya lonko etele masoto.
As lawyers we know this about law.
Lawyer lu ntelu nga lonne ko loi be wonyale.
Law is merely a command that can be enforced by sanction.
Loi mu kanneti mensi tamano ko lu sarto lu landinyala.
Were the decrees law during the transition period?
For decree olum ketaluati nunu sango falingo be kekan wato men.
To the extent that they reflect commands which had sanctions, which had consequences if you don't abide by them.
Kata hanu fo
those that were directed at people.
Ka foko ye sembo ning kango sotole men ya lonko isi tamandi sartolu la tamanya la karola molu la karola.
Maybe you can call it law.
Ase keno ye kumandi ko lualom.
But to the extent that the Gambian people did not have the military did not have the consent of the Gambian people to make the decrees.
But kafoko sojaro lu manyin council of Gambian ko lu kafoko decree lu de la.
And they were not laws.
And odumo manke luati.
That's a philosophical debate.
I was about to say that, Mrs.
That's a
Bensouda.
philosophical
Looking at the practical realities on the ground, as far as the Gambian public was concerned, the decree certainly had the force of law. As far as the military junta as well was concerned, they ruled by it and used it as law operated in the normal setting. And by these decrees, remember, Mrs. Bensouda, you drafted them, they were equipped with legislative, executive, as well as judicial powers.
Ando Ms. Bensouda, nyin dikiril min ka foteng andi teketa moti mi yalan ko itala deda ye symbol le ke je mi yalan ko len kiti bunda sembo loi deda sembo ani mi yalan ko man sakunda nyaton ko la sembo fana.
And these decrees actually validated their own unconstitutional actions.
Andum fana nyin dikiril keta fenati mi yalan ko ye londir ke ko la mi yalan ko akamtalo ko doro ning banko loi boko babe tamaka.
And in your position, you helped them to achieve it.
Ando ite fongo kundingo watu mene bo makamota iketa multi mi yalan ko ye demale pour ye ko tamandino wanyama.
Well, the premise of your question, if the question is whether I helped them, that premise, of course, is wrong, and I don't agree with it.
Ilo dinkira kafo nyinin karo kono kafo kufa fodu ntele imako yukulu tamandola natara wole mude woto manso woto la mbafala ko woto dal amanke kuti ntenya ko to mentilinta.
And I respect your answer, Mrs. Bensouda, and I will allow the commissioners to draw conclusions.
Ila jabiro mba bunya la bakale andu wakang mina abula commissioner bulu police jiberke ya woko nyintame ya jibe.
The decrees did not validate anything done by the council. They did not need validation.
Decree olumam fewo fendi bambandika londi ka foko nyimuku ketalti council nyin nakarola. The
decrees provided a framework for them to operate, in which they operated. It was created by them. It was enforced by them. It was amended by them when they saw fit. In fact, even where the decree said they could not do something, it did not prevent them from doing it because they had the power to do it.
Then
one might ask, Mrs. Bensouda, then what's the point? What's the point of the decrees if at the end of the day they would have done what they were going to do without it, and they were ruling anyway without the power of the decree? Then what was the point? What was the point for all of the framework and guidelines that you presented in the decree in that case? Because they were not bound to follow it anyway.
What is saying, Ms. Bensouda? Most in karo kenol. But in saying you'll more let me uncle decreeing. Hanatara lota, what a balla, it will left a cuckoo kele bakela, far tata insular, farmantan insular.
In my
view,
in my view, I mean, you might as well not have dirtied your hands by touching them. Just let them do what they're going to do.
Until a miralota, Imanya Dakala Nunje for a bullon nondi, then the Yenta Silla ye fele, told Beminkeka ye walk a
I do not consider my hands to be dirty.
I
do not certainly consider my hands to be tainted.
But
it's a fair question to ask then, what is the point? I suppose it's convenient 25 years down the line to be asking those questions. Were we all to abandon the country and leave it to Yaya Jammeh and his cohorts? Should I have resigned as Solicitor General? Should I even have stayed in America? These are all hypothetical questions 25 years down the line. At that time, with having worked in the ministry for 5 years, Sorry, for 14 years. 14 years at that time, having been Solicitor General for 5 years.
And
knowing that the situation we found ourselves in was not unique to Gambia. And taking a point of reference from how other countries, Nigeria, Ghana, Liberia, Sierra Leone, how all of them have dealt with the situation.
Ko banku dolu ya akwoke nu nyami mbiri aketela bankolu kang menube ko Ghana, Nigeria ananyom banku kotengolu niyo santingolu jube.
I took the decision
ngawo kangota nyine kang
to come back
purka murunang
and Solicitor General continue to work in the public interest as is my oath.
Solicitor General purka continue do ko la jama mulu toyala wairi ngakalioleke.
So, in your view, you were some sort of savior, Mrs. Bensouda. That's the picture I have in my mind when you describe the situation where if you had not actually intervened, this country would have gone down the line of chaos and anarchy. But for your intervention.
Coming ntala miralo to ngaja nyami wala nyintiko komi na tara no ita manne dabula nyunko konono deno nyim banko be kala bankule de mialan ko kairo nin tenku ngoda tara no nin banko kan wo wato kono.
Savior, I wish I was. No.
Ka fo kanandirla ngam asidia nyunu ngakewoti hani mankewoti.
I really wish that the military who had the responsibility to secure the safety of this country.
I was
no savior. However, the country was in anarchy. And what is anarchy? Was in a state of lawlessness. Where soldiers can knock on your door and throw you in prison. Other countries put in a coherent framework so that the military could interface with the public. And that's all decrees are supposed to do. Create a framework so that people will know what to expect from the military. And hopefully, the military will also understand the limits of their own actions. But let us not fool ourselves. The soldiers were in control and could do whatever they wanted. The decrees did not enable do anything.
But Mrs. Bensouda, it's very clear that the situation you explain about regulating and stabilizing the situation, I mean, it definitely did not happen. Perhaps that was your aim and that was your objective, but it definitely did not happen. And you have also confirmed that because they did what they wanted. Do you have any regrets?
Ms. Bensouda, mimbi je wala nyintiko ita natala nung pruka demarke isaje kuol belari nun nyaming tinyarol mimbe kering a besebo wala mwila hamendatu nung barkabri nata inata ajele ko wo kuol nying wo hamendal nying iman na wo natol timandino sa mbe nying kalamina fo ini misata nyung kuol lalabang milketa.
Regret about what?
Kanimisa munna?
Specifically.
Tombondiroto kanimisa munna?
Regrets about drafting the decrees.
Wala nyindiko yewo nyindikri lual miyalanko yewo le deda nying juntamoli.
No, whatsoever, none.
Ani akitanya nyandi nyama fentiji.
Okay, thank you.
A framework was needed.
Amunta kolu lanya na sambanya solo be wala lanu.
Even though it wasn't followed.
Ana telefon call man
and it was disregarded, as you said yourself.
Andu imanna kuma andi komite fon ya fo nyame.
Not everything. I did not say all the decrees were disregarded.
Mafoko ye nya kasi decree olubele la.
You said the soldiers did what they wanted to do
Ko soldier
from the beginning, even before the decrees were passed.
I telefon wo decree
So
loi
therefore,
ni me
what was the point?
Say what munen wo daliloti.
Let me repeat. The point was to create a framework within which they could operate, whether they followed it or not. That was the framework.
Sarto momenti wala mnyinti ko ka kuolu sambanya ning atamandinya parendi. Itatabula wonoma bang, imanta bula wonoma bang, bari ninku de data me yalonko anyanta kela wole nyama, adadata wole kama.
So even if it served merely decorative purposes, it should just be there as a guideline, even though no one was guided by it.
Ana tara num fa ya dedala no re komi ya ke nyarandiri fengoti tendorong amanjari num fenna fodi.
I think it's a wrong opinion to say that they serve decorative purposes.
Namera nyimang tilin kafoko aketa nyarandi fengo damanete.
Just to give an example,
Ruka misalo di
Decree number 1 enabled them to, although they had made a declaration about the cabinet.
ye kuma kangolu fola cabinet la karola bar decree number 1 fananata nyi silo yitandi.
Decree number 1 gave them the structure within which the cabinet members could be appointed and could sit to address the myriad of issues that had nothing, that the country needed to be addressed, that had nothing to do with the military.
Decree following wole ye silo yitandila inyanta kulu tamandila nyami inyanta kulu londila nyaming me ya lonko itella mararo kono be kulu tamandila wole nyama. Decree following yo bundale yele itelie puri salon be kulu sambala nyaming.
The decree also enabled the government to know that it will continue to function under the laws that were in place.
What decree fanane nyi yitandila ko ibe tamano lale lua lukoto menia lonko wolebe loring inyatili nyal.
In other words, decree number 1 enabled the public to know what the situation was and enable life to go on.
Decree following na fanan nata jama mako e puri ya long munebe caring anim fanan puru molu la sinya nim balunya sitenteng.
In other words, decree number 1 was the MOU, Memorandum of Understanding, between the people and the military, if I may put it that way.
Ninsa fono wonyama decree following wole mu nyofa hamu county jama molu ni sojaro lutema otembo.
Just like a constitution is the memorandum of understanding between the people, the governed, and the governors.
Constitution mu nyofa hamu county nyaming jama molu iniman sakunda ning maralu bunda lutema.
So we should not infuse it with some other, some other attributes that.
Yeah, Mrs. Bensouda, just to conclude, really, certainly it is clear, even from your own testimony, that the junta never had the consent of the public to do what they were doing. So I don't see how you could call that an MOU between the people and the junta. You said their government was illegitimate, and, we've gone through all of that. So I don't see how that could be an MOU.
Miss Bensouda, comme il faut faire nyame, nta maje comme il ka fana min fo comme banko loi nying buko banying woning mol tema comme iko mu feneti nyana ka fa memorandum of understanding wala nyomo yole be kering da mol tem o man ka fenti mi alon ka keta wala nyam bunya be kamala.
But in order to
it's a good point
Bunda nyimalam
that you make.
Thank you for acknowledging that.
The memorandum of understanding did not require the consent of the people. That is true.
Not that it did not require it. It did not have the consent. The people never consented to this.
I think we are saying the same thing.
I'm not too sure, Mrs. Bensouda. I doubt if we are saying the same thing. I'm saying something very different.
It did not require the people's consent because they were ruling by the barrel of a gun.
And the people never consented to that. Sorry.
I mean, one can debate all these issues, mostly philosophical, but let me make it absolutely clear. And I
would
like to underscore it.
ndumbela flaka bambandi
I take no responsibility for the actions of the military.
sojaro labara kolunta ak femfem duno tala je.
And for those of us who try to stabilize the situation,
Ndel dolu men ya katapurka kolu tembendi ka tilindi.
I think we, in fact, are entitled to commendation.
Ngamira nyanta jairo sotonnale.
I feel neither tainted by what happened or the role I played.
Akatung maje ko ngako men tamandi ani menketa amanke kutime yente nondi.
And whatever I did was entirely consistent with my duty to the country and my duty as Solicitor General.
Nga femfenke kule me ya lonko.
Or acting Attorney General.
Anim banko la solo ni sartolu tata nyola le anim fanam palaso membembulo tumo Attorney General makamo anio fanan na sartolu ni tarambulo tata nyola le.
And I understand your point about not taking responsibility for the actions of the AFPRC.
No fananga fahamo kele munati ne mansong coming ning AFPRC mansakundany wala junta nyinti la manyal mi yalanko ye wala keno.
And let me just
finish my point, Bensouda, so that I don't lose my thread of thought, please.
But let me just
finish, please. Please, with all due respect.
I'm at the listening end, so I'll give you priority, yes.
Thank you very much. Yes. I really appreciate that. Despite the fact that you're saying that the AFPRC did not actually you've succeeded in helping me to lose my trend of thought, which I'm sure that was your
I'm glad
your goal.
not really. I'm glad you understand my difficulty when you make these long statements and expect me to answer.
Okay, go ahead and answer, and then by that time
I just wanted to add, and I take no responsibility for the decrees. I take no responsibility.
Very well. You have now reminded me of my question.
Yes. I thought you were going to, in fact,
yes,
yes.
Yes. In terms of coming up with the concept and the idea, the blueprint for the decrees, I understand that. But do you not take any personal responsibility for assisting in their drafting? Coming up with an actual decree and placing it on the table of the junta?
I don't understand why I should.
They had no know-how, they had no skill to draft decrees. I doubt if they could have made an effective review of those decrees at that point. They just took whatever you said, as far as I'm concerned.
It all man londi soto komi word decree ni nyanta ka de da nyame. Andu na taro num fa yel fellon nu jefa. Denu kabi wato minete ya de da be min kala ni ba sen kan jibe la ka jibe yemin de da. Bari mo fon keno.
The suspension of the constitution, suspension of the courts, and all of that.
Because kiti dunkral deng ka bankola bukulua ba fana deng.
But it was reiterated in the decrees.
But why
was there need to do so? If their actions had force of law anyway. That's what I'm trying to understand and reconcile with. And I think that the general public as well really would like to understand that. You know, as you said, sometimes there can be a philosophical debate as to what is law and what is not, but in practical terms, what was operating in this country?
But honey
what was operating in this country before the decree was nothing.
Nothing
was operating.
What a fenty.
When I came back, nothing was operating. For the 1 week, the military were doing exactly what they wanted. And people did not know. And people did not know the framework within which, what was going on, the framework within which this military were operating. I call that anarchy. So maybe I don't understand
the framework really had nothing to do with what they were doing, because they continued to do what they were doing anyway. The framework did nothing to limit them or restrict their actions. They continue to unlawfully detain people, they continue to torture people.
I continue to kamol treasury, I continue to kamol mabo.
Even after passing of the decree.
I atara fang janibe wo decree luani.
So what was the framework all about?
Say what munen tamandir bulol nyimbe mumeti.
You must remember also, I mean, I agree that they continue to do what they wanted. So decree or no decree, they would do what they wanted. Right?
Sondra ko be kolu ke kan ne laftala nyamin decree lomban decree ntebang itelbela kolu ke kan ne laftala nyamin.
You must recollect that the vast majority of the decrees that were passed during this period
had
nothing to do with the arrest or detention. These were just regular decrees that would have been passed in the National Assembly for the good functioning of government.
But for now, and for the purposes of the TRRC,
no,
Mrs. Bensouda,
it's very important to put TRRC cannot be the issues of the decree in the TRRC cannot be handled in isolation. There wasn't a set of decree that had a life of its own that violated the rights of the people, and another set of decrees that were applicable in terms of the functioning of government and so on. The decrees were decrees. So yes, when it came to the decrees that affected the liberty of the subject, the sanctity of the human being, this is what the TRRC is looking at. But it should not be looked at in isolation. So I'm quite concerned that the decrees are being infused with some sort of, I don't know, attribute that don't exist. Decrees were just rules that were put in place. Now when it came to...
TRRC be jube romen ke kan wolam ka jube o dikrilu ye londi ay men sababu akola aning akata menti ibewle jube kan pour ka kusanu soto je men muto nyati dikriolu ye men sababu ani mam men sababu bar ni aji be fanan wolu kolu mukulleti men yalon ko nyilu bela kolu ke kan dikri bi soto taban dikri man soto bang itel bela kolu tamandi kan nyaado nyama hani wato me o dikriolu mallo.
Because of our mandate, Mrs. Bensouda, because of our mandate to investigate human rights violations.
I agree that there are a set of decrees. There were a set of decrees that, of course, are crucial to your mandate.
Yes. We must focus on those.
Yes, decree number one is not one of them.
I disagree.
Decree number one, yes, of course. The decree number one merely set the basis for government by the military.
Decree following kolu lanya le yitandi sojarolu la inyanta ilamansa kundata man.
What about decree number 3? Do you agree that there was room for the junta to violate human rights through unlawful detention?
Decree number 3 nyundum foya mira we silo di junta la priya hadama dungo la nyanto tinyabang.
No, in terms of Silodi, as he put it, it did not...
I don't understand Mandinka.
It paved the way.
It paved the way.
You are agreeing that it paved the way, or you're not agreeing?
No. They were already violating human rights. What the decree did was to set down a procedure which should be followed if people are to be detained. There must be a detention order. Yes, it did not take away the right of the vice chairman, his discretion, which he refused for it to be taken away. It did not take away his powers to deal with the detainees in terms of where they should be remanded and so on. But it put in the minimum that I think we should be, I and Cherno worked on these things.
Decree follow dali lomenti wala mnyenti ko kasilolu nin tarambulolu londi ning itelu sonta nung purka tama menula men ya lonko wolebe kala kukendolti isi mararo keno nyami ndani Cherno denta ngawo silo le doku ya lonko wolebe kala tarambulolu
ebe Cherno jumale ka Cherno jumale foto.
Oh, Mr. Cherno Jalo QC. He's now a Supreme Court judge.
Supreme Court
We grew up in a democratic, as lawyers.
Ntelle menta nyola democracy silo kan komu loyalty.
We grew up in a democratic context, in a context where fundamental human rights were supreme.
Mbe kuluta nyokan democracy la sarto le kono ko loyalty adu mu kuleti me yalonko.
So how could you put your name to these decrees, Mrs. Bensouda, taking that into consideration? I mean, with everything that you described about the democratic setting of Gambia and the respect for rule of law and human rights, and then you assist in drafting, or I would say that you drafted these decrees that suspended the constitution.
Komi nata silol mi itandi komi Gambia banko kan demokrasi kata manyama hada madungol la nyanto hani wobe etenate dabula nyin decree economy alan ko yewolle de daten.
Ousted the jurisdiction of the courts and gave legislative powers to the
ka kiti bundal deng ka sembo di mo la mi alan ko lebe maralo ni wo wato kono.
That is not in consonance with democratic principles as we know.
Woman ka fenti mi alan ko esa kunna dino la nim ko la mi alan ko democracy nyanta ka tam wala nyama.
So in my view, I would not have touched those decrees.
Ntala miro to no ntala mtembulo mala wo decree lu ala.
But your opinion is that
but although
you don't want to say the word savior, but you did come to save us.
I'm glad you are not me.
Indeed.
We acted responsibly.
Mrs. Bensouda, I think we'll agree to disagree at this point, and we'll close for the lunch. I'll just refer you to the chairman before we do so. We will break for the lunch, not close. We'll come back after lunch. Thank you.
Thank you, Thank you, Council, and thank you, Madam Bensouda. We will resume at 3 o'clock sharp. Thank you, meeting's adjourned.
Thank you, Mr. Chairman.
Yeah.
They say we slept in one world and woke up in another. This global tragedy got humans together despite our social